notice and comment, for example, which means you must.
No. It's the road closures. They're just, you know, you're in charge of road closures and you think it would be a good idea if citizens knew about them. So you're announcing the road closures on your site.
Yeah, and if there's not a specific duty to announce the road closure, which is, I gather is what you're saying, then if you choose to do it on your own site, that's exactly the sort of thing where we think the nature of the property.
Okay, that's not Mr. Mupan's answer. Mr. Mupan said that as long as there wasn't a government site where the road closures were being announced, that would be state action.
If there's a duty to announce those, I took, as you framed it.
It's not a duty to announce. You're in charge of road closures, and you think it would be a very good idea if people understood where the road closures were.
Yeah, and it's, again, I don't want to speak for Mr. Mupan, but that sounds like the kind of thing that a private citizen could do. Let me give you an example closer to the school board case. There are often...
Well, why don't we do my example? Because how are you going to know where the road closures are? I mean, now you're being, I thought that we were starting off from a point of if the only place that somebody can know where the road closures are is on your private site. Mr. Mupan said that was state action. I was going to go on from there, but you seem to be contesting that.
I guess our view is that if there's a specific duty to make that information available.
It's not a specific duty, Mr. Joshi. Duties don't work like that. You're in charge of road closures. That's your duty, to be in charge of road closures.
And if you are not obligated to talk about road closures and tell the public about road closures, if you do it on your private site, then I think you are probably acting in your personal capacity. Now, I agree, there may be duties to inform, and in those cases, if the only place you do it is on your personal site, that may well be state action, whereas if you do it on both sites, it wouldn't be.
The Sixth Circuit seems to think that the duties have to be written. But many duties are customary, meaning, no, you're right. I think if you're in charge of road closures, I have very little doubt that there's a written law that says you must inform the public. But that is what everybody does. It's what tradition and process has always provided for. You're suggesting that that would not be taken into account.
No, not at all. Quite the opposite. We agree that customs can define the duties. I think I was just saying.
So you don't agree with the Sixth Circuit's narrow view that it has to be a written duty?
We do not agree with the Sixth Circuit's view that it has to be written down. We agree that customs can inform what the duties are of an office. It's just, if there is a duty to inform, then the discharge of that duty will be state action no matter where it takes place. But where there's doubt about it, if what you're doing is denying access to personal property, we ought to think you're acting in your capacity as a private property owner, not as an agent of the state.
Thank you, counsel. Justice Thomas? Justice Alito?
Would it be practical to require or adopt a rule that puts a lot of pressure on public officials to separate their Facebook pages, just to take that example, so the official can have a personal profile, the official can have a campaign page, the official can have an official page?
Those all sound like wonderful things that a state government can impose in its capacity as an employer. I don't think this court should impose it as a matter of federal constitutional law. And it certainly shouldn't be the case that the Constitution imposes that kind of precondition in order to exercise your personal constitutional rights.
Well, Mr. Mupan said that would be unrealistic that would be asking too much of a lot of public officials.
I do think it would. I mean, take the example that Justice Jackson brought up with disclaimers. You know, you might think, well, all you need to do is put up a disclaimer and that's it. Well, how good a disclaimer do you need?
Right,
Does it have to be on every page? It's just going to chill speech.
Justice Sotomayor?
That's all.
Justice Kagan? Justice Kavanaugh?
To pick up on what Justice Kagan was asking, which about the road closures and announcements of rules, announcements of information, and what have you. When I was discussing it with your friend, we were assuming that it wasn't also posted on the government site. It was only posted on the personal site. And then asking, okay, where does it cross the line into governmental? Why does it matter that it's posted on the government site or not?
I guess it would matter because that would inform just as you look at the facts of a case, whether you're acting in your personal capacity or in your official capacity, which metaphorical hat you're wearing. And if you've discharged your duty, again, assuming there's a duty to inform the public about these things, if you've discharged a duty on the official site and then you're amplifying it on your personal site, odds are when you do it on your personal site, you're doing it in your personal capacity. But if your boss tells you, go, inform the public about this road closure, and the only place you do it is on your personal site, you're probably discharging your official duties.
Okay, so it sounds like both of you would have, in essence, a safe harbor that if you're reposting information on your personal site, that's probably not going to be considered governmental.
Yeah, and that's exactly right. And I think, I take the point that the other side makes that might be under-inclusive in some cases, but I think that's better because that is the purpose of the state action doctrine, is to preserve an area of individual freedom and not hold the state responsible for conduct it really can't control.
Thank you.
Justice Barrett?
So going to Justice Kagan's questions about announcements, et cetera, if individual posts on a personal site can ever be state action because you have a duty to make announcements, is that a situation in which your property framework where the presumption is just defeated because it's a personal account in which you sometimes use for official purposes?
That's right. As I mentioned at the outset, if the official duty or authority you're exercising is one that requires access, like notice and comment or an official school board meeting where the public can speak, then yes, that's state action no matter where you do it, and your blocking of someone from accessing that particular action is going to be state action no matter where it occurs.
But the word duty is important to you. So I asked Mr. Mupan about duty and authority. You're really leaning on duty, and it seemed in your interchange with Justice Kagan that you saw a difference between duty and authority.
Well, I think a duty, it's less obvious in these cases and more obvious in the next case where he's a subordinate with a supervisor. So duty is important because you need to know, is he actually discharging the thing he's supposed to do? An elected official, like these school board members, don't really have much in the way of those duties, but they do have authority. They can invoke the state's power to do something that someone who doesn't have the state power can't do. And so in that sense, duty and authority might be different. In Griffin, for example, that was a private security guard at the Glen Echo Park, but the reason he got his deputy sheriff certification was so that he could make his arrest and his kicking out of the trespassers more effective. People listen to deputy sheriffs in a way they don't listen to.
That was authority, not duty, right? Because
That was
have
authority.
A duty to
That's right.
arrest anyone.
That's
Okay.
right.
Justice Jackson?
So can I just go back to Justice Alito's hypothetical, which I thought was really good, and ask this question. Suppose the public meeting doesn't occur. So we have the mayor of the town, and there's this controversial policy, and there is no public meeting to start because the mayor fears that there's going to be quite a bit of acrimony with people who want to come out differently than the mayor does. And so instead of the public meeting, the mayor says privately, I'm going to have a meeting on my farm, or maybe he even announces the meeting, but we're only letting in people who are likely to agree with my view. Same result, no state action in that situation?
I think probably no state action in that situation. I think it's something that government officials actually do all the time. They might not want to meet with even their own constituents who disagree with them. They might speak only to Democratic Party meetings and only take feedback from Democratic Party donors. And the solution for that, as I said, for elected officials might be the voters, and for appointed officials and employees, the state as employer can regulate that kind of behavior, even if it's in its personal capacity.
But it doesn't have to do so specifically. I mean, can we believe that, say, the mayor's duties include receiving feedback from the public? If there was a duty to get feedback from the public, I understand you to be saying that he would have to.
Yeah,
that even if it was on his farm, he couldn't block people, or it would be considered an official state action.
I think it would have to be a pretty specific duty for that to constitute state action. I think if the duty is too broad in general, like speak to constituents, I think that's exactly the kind of case that our heuristic, our test, has a lot of purchase, which is if it's something that a private citizen can do, talk about a policy, get views on a policy, advocate for a policy, but also within a sort of broad conception of official responsibilities, then I think the nature of the property to which access has been
All right,
denied
one
really
final
ought to-
question, just as a sort of theoretical matter. Does the government have any concern about the potential privatization of government functions that could occur? I mean, I suppose I'm a little worried about city mayors deciding to sort of shape the debate of the people in their community by having their meetings in private places so that others in the community can't comment. That seems to me problematic as sort of a theoretical matter, but the government I'm taking says as long as the mayor chooses to do this on private property, then he can exclude whoever he wants, and because he's doing it in his personal capacity.
Yeah, I mean, in the brick and mortar world, I'm not aware of this being a problem. And if it is a problem, I think it's best handled by the state, which can regulate its employees in ways that a state as sovereign cannot. And I think that's the best place to handle those concerns, not a rule of conduct from this court as a matter of federal constitutional law.
Thank you.
Thank you, counsel. Ms. Carlin?
Mr. Chief Justice, and may it please the court, I have 3 points to make. First, the district court found as a factual finding based on petitioner's own testimony that, quote, receiving feedback from constituents is an important part of their duties as trustees. California law, both decisional and constitutional and statutory, the PUSD bylaws, to which I'll return in a moment, and the content and appearance of the page confirms that the district court's finding that these pages were, quote, used as a tool of governance. Because the trustees were doing their job when they maintained and then blocked Dr. and Mrs. Garnier from these pages, this case fits comfortably within this court's declaration in West and Lugar that state employment is generally sufficient to render the defendant a state actor. Second, the record in the district court contains O'Connor Ratcliffe's entire Facebook feed from the time she joined the board through summary judgment. Of the hundreds of posts, I found only 3 that were truly non-job related. Not only were the posts all related to her job as PUSD trustee, but the district court found that the content of many of the posts was possible only because as a trustee, she was, in the district court's words, clothed with the authority of state law. For example, O'Connor Ratcliffe's official position was why she could enter into classrooms during instructional time all over the district, something that would get anybody who was a private citizen arrested. Not only did she use these pages to provide information about her official activities that was available nowhere else, but she frequently solicited feedback from the public on board-related issues and used the word "we" to do so. And I'd like to direct the court to page 46, note 12 of the red brief, where we cite the requirement by the board that you have a disclaimer if you're speaking in your personal capacity. She never put that disclaimer anywhere. Instead, she asked people to contact her using her official government email account. And third, the pages at issue here are in no sense campaign pages. The district court rejected that argument on pages 114 to 115 of the petition appendix. She did have a campaign website. That website had a personal email address, unlike her official email address here. I welcome the court's questions.
Ms. Carlin, the petitioners here and respondents in the next case make much of the fact that if your broad definition of state action is accepted, that it would actually reduce speech by public officials. I'd like your reaction to that.
No, it would not. No one has challenged the speech that was on these pages at all. If they're speaking as government officials, they have both the government's own protections. So, for example, there are a number of protections that go to government officials when they speak in their official capacity. Plus, they still have all of the First Amendment rights as a backup. And I think it's really important to note here that all we're talking about is the state action issue. And the idea that government officials are not going to want to talk about their jobs at all if you tell them it's state action just seems to me to be illusory.
But I'm not sure about that. I mean, if it's characterized as a state action, governmental site, then wouldn't anything they say be categorized as governmental speech on which the government could take a particular political, social, whatever view?
Well, I think that it's actually perhaps a little more complicated than that, Mr. Chief Justice, because these are elected officials, and part of their duty is to talk about certain issues. And I think if the government told them they're simply not allowed to talk about their position on what the board is taking or the like, that itself would violate at least the California Constitution and arguably the federal Constitution
Well,
as well.
just to make sure I understand, we're characterizing a particular site as whether it's governmental, a source of governmental authority, operated as a governmental duty, or private. Now, if it's private, the people talking on it can say what they want. Their speech won't be limited. If it's governmental speech, they have to do what the government tells them to do on that site.
Well, I think the one thing that they do have to do, and I think this is fair, and there were a number of questions of the folks representing the petitioners here, they do have to have a disclaimer here to say this is a personal site. They did not have this disclaimer. Ms. O'Connor-Ratcliffe instead says, if you want to contact me on my official government email account, which she's not allowed to use for personal or political purposes.
Your test is,
Sorry.
your test is whether government officials are doing their jobs, right?
That's the starting point, and it creates what I would say is a kind of rebuttable assumption that when a government official's doing her job, she is a state actor.
All right, so the mayor is in the grocery store and is repeatedly approached by constituents, and the mayor listens to, really doesn't want to be bothered, but listens to supporters and people who are sympathetic to the mayor's program, but if somebody who is a known opponent approaches the mayor says, look, please call my office. Is the mayor doing his job when he's doing that?
I think the answer to that question, which is, I think, different than the answer I would give in our case, is that when they are clearly off duty, that is, pushing the shopping cart down the aisle, arguably they're not doing their job. But when they create an ongoing site, like the site here, they maintain a forum, if you will, in which people can comment and people can talk to each other. They're not just talking to the mayor, then yes, that would be state action.
I mean, elected officials have told me they're always on call. They're always doing their job. They're always being approached by constituents.
But if they say they're doing their job, then yes, I would say the starting point is they're state actors. Now, can they say, I don't want to talk to you right now, the ice cream is melting? Of course they can, because that's not violating somebody's First Amendment rights.
But if they're discriminating on the basis of viewpoint and they're doing their job, then there's a problem, right?
Arguably, yes. But that's why I was saying that I think when you are clearly off duty, you're not doing your job. Even if you say you're doing your job, you're not acting in your official capacity. But here, there was a website. There was a Facebook page. The Facebook page says, if you want to talk to me, contact me at my official office.
What if what if all of her posts were done in the evening? They were all done between midnight and 1 a.m. Is she on duty then? Is she doing her job then?
Yes, in the same way that if you stay up till midnight and you're reading briefs at home, you're doing your job, you're under color of law. Nobody has a First Amendment right to come into your house, but of course you're a state actor.
Could we go back to what you said about disclaimers? Would a disclaimer turn this immediately into private action?
No, but it would be a much harder case for my clients to win.
Why no?
Well, because you could say on the top of your website, this is my personal website, but then be operating it as a tool of governance.
Yes, so that's my, if it's the same content and if you in fact are operating it as a tool of governance, but you have a disclaimer saying that you're not, that this is just you as a person.
Well, I'm not sure that the court wants to have a magic words test for state action. And so you would still, I think, have to look, but at least there, the public would know and be able to take into account that you are not using this as a public website. Here, I think putting the disclaimer there, but then saying things like, we want you to respond to our surveys on whether we should change the election system. We want you to respond to our survey. We are working hard She's not using I. And if you compare this to her campaign website, which is a website, not a Facebook page, there she uses I. Here she uses we. And honestly, as Mark Twain said, the only people who should use we in the singular are royalty and people with tapeworms. And, you know, I don't think she's either of those.
Ms. Carlin, do you think you could win under the test proposed by the government and Mr. Mupan? Because, I mean, I feel like you're talking about doing your job, and it seems like you're saying that she's exercising the authority of her office, whereas the Ninth Circuit focused on this appearance and function test of the website. But it seems to me that you're saying she was doing something more.
I think we obviously win under the Ninth Circuit test,
Sure.
but I think we win even under the Sixth Circuit test because of the duty. And I can, if you want me to tick through the different places where in state law and board rules and
That's
the like.
okay, because that was in your brief. So
Yeah.
but that's what made me think that you're saying it doesn't really matter. You would win under that test because she had the authority.
Yeah, I think we win under every test except a strong version of the Solicitor General's test. Because under that, because Facebook itself, the Facebook account itself was not owned by the government, that's a hard test for us to win under. Now, we still
But
do have
they've given that up because they're talking about function, really.
Yeah, I kind of
Yeah.
like to think so.
Yeah, I mean, they said if you do notice and comment whether you have other postings is irrelevant, you're looking at the function of what's happening, correct?
Yeah.
So tell me how your test, doing your job, differs from the authority or duty test of the Sixth Circuit. What do you?
Yes.
Okay.
Yes. I think the Sixth Circuit has a much narrower sense of what duty means and what authority means than we would say is encompassed in doing your job.
I agree with you on duty. They
Yeah.
require a written law on
Yes.
duty. And the government has already conceded that you can't look just to written law. So let's take Justice Barrett's point that authority is doing most of the work, and authority has a meaning. So go ahead.
So as I read authority in both the government's brief and the Sixth Circuit, they're treating authority as you're exercising some coercive control over a member of the public. I take authority to be something quite different than that.
Give me a,
So
you're going to have to explain that better.
Okay, so if I understand the government's brief correctly, what the government says is, well, of course, even if you're using private property, if you're using it to coerce somebody, so on your private website, you said to somebody, you're fired, and that has the force of law, that would be state action because you're using an authority that only you have. Right? I as a private
they
citizen
admit that notice and comment would not be coercing someone. So.
No, but I mean, I take it what they're talking about there is a particular kind of authority. Now, some of the posts here are because of her authority as a state actor. The modal post on the site, I would say, the thing that is most common on the site is that she goes and visits a classroom with the superintendent or with a principal during instructional time. The only reason she can ask to do that, the only reason she has the power to do that is because of her official capacity. No person could do that. No member of the public could do that.
And presumably that's not put on the official site, whatever that means.
No, as far as
it exists only on this site.
as far as we know, the only place that you could go to find out about her
So
class.
basically your argument is that it facilitates. Her
Yes.
government authority facilitates her doing a government function and permits her to video it and put it on the site.
Yeah, I'm not sure how many videos there are, but yes, she
Yes,
has
sir.
reports of them.
But just if I could get you to say that in one bit, if you said, you know, the right way to think about duty and authority, if you want to use those words, is what?
The right way to think about duty is to look at the various sources of state law that tell you what somebody's duty is. And here we've got the California Constitution, the board bylaws.
Right, but stepping back from your case, which,
Okay.
you know, I know you want to win your case, and
I
good.
I do.
But just stepping back and saying, does the Sixth Circuit have too narrow a view? I thought you were saying yes.
Yes.
How is that true? Why is that true?
Because the Sixth Circuit says unless there's an affirmative command that obligates you to do the specific thing you are doing in the specific form you are doing it, you're not doing your duty. And we think that duty has a much broader conception. And I want to be clear.
Which is what?
which is you look to what does state law tell you what to do, what does history and tradition tell you what to do, what do the bylaws of your organization tell you to do, if there's a handbook, what does the handbook tell you to do, and those things can be optional. They can be acting in your discretion. This court has repeatedly said in a number of different contexts, going back to the McDaniel case in 1833, that if you're talking about really people with important government jobs, it's not all going to be written down.
Counsel, I guess I'm a little confused as to what's at stake here, because I hear you saying now it isn't a matter of appearances and whether a reasonable person might make a mistake, which was kind of the Ninth Circuit's reasoning. It really does boil down to duties and authorities. And you're positing that those duties and authorities include, beyond what's in a handbook, and must take account of custom. But I had understood the Solicitor General to say exactly the same thing. So are we coalescing around a test that everybody more or less agrees on?
Well, I want to be very clear. I was talking about duties authorities in the context of Justice Barrett's question. We think that the appearance and function are also relevant to whether someone is engaged in state action. I took her question to be, if you take the Sixth Circuit's verbiage, do you win the case?
I'm asking, what's wrong with something like that? Is there a problem with it? I mean, it seems
well, I think,
this discussion does seem like it's coalesced around an understanding of duties and authorities, and there's some discussion about how capacious that has to be, but really the discussion seems to me like you and the Solicitor General are on all fours.
Here's the one thing that
what am I missing?
Here's the one thing that worries me there, and it goes back to this court's decision in Home Telephone and Telegraph in 1912, but also involves Monroe against Pape, which is lots of time people do things that they're forbidden to do in the course of their job, and they are nonetheless acting under color of law.
Sure.
Yeah.
We're all sensitive to Monroe versus Pape and the Griffin case and all of that. Everybody is. But given that, do you see any problem with what we've been articulating here and you have with Justice Kagan as to any of that?
I have no problems with the things I've said so far. I just think it's more capacious than just that in trying to figure out whether someone is acting as a state actor. When you start with someone who's a government official, and I think it's really important to remember that this court has had in its entire history, as far as I can tell, about 3 or 4 cases where the question was whether a government official was a state actor. And in all of those cases, except Polk County against Dodson, which was the case about public defenders, the court said, of course you're a state actor if you're a government official. So I think the presumptions and the rules of thumb and the like operate a little bit differently here than they would operate in a case that involved someone who was clearly just a private actor, and you're asking, can you push them over the line into being a state actor? Here we start with somebody who looks like a state actor, says, email me on my government official account if you've got any questions, says, this is the official page of me, uses the photo and like, and I do think all of that helps.
But
Well,
she has
I
the
understand you. I understand you want to win your case, as you said to Justice Kagan, but we have to be concerned about the test. Now, I understand you to have said that you would define duty to include custom, a well-established custom, and is it not a well-established custom for any elected public official to inform constituents about what he or she is doing? So if that's how you understand duty, then are you not saying that anything that an elected public official, let's leave it at that, tells constituents about what that person is doing constitutes state action?
I think the starting point is yes, they could rebut that. For example, talking, at Thanksgiving dinner, somebody says, pass the gravy, and you say, and I also passed a bill last month. Yes, that would be private. Whereas when you set up, and this is what the Ninth Circuit says on page 28A of the PET app, is the state action here is maintaining an ongoing site for the exchange of information.
Well, I understand that, but what I'm getting from this is that you have taken the Sixth Circuit's test and the petitioner's test, and you have broadened it by defining duty so broadly. And maybe this is right, but you have made it into a very broad test. a very inclusive test.
I think if you want to use the words that the Sixth Circuit used as your guidance, you have to broaden, and our case would clearly fall on the side of the
Well, let me go back
state action.
to your wording.
Yeah.
And ask you to finish this sentence for me.
Yeah.
A public official is doing his or her job when?
When, if you look at state law and you look at the bylaws, they presuppose that they will engage in precisely the kind of action that you're challenging. Well, I have two last.
If you're a White House press secretary and you have a dinner at your house and you invite over certain members of the press and not other members of the press, because part of what you think makes you a good press secretary is to get feedback and develop good relations with members of the media. Is that state action?
Can I take that question and kind of flip it around and go backwards into it? There would be no constitutional claim by anybody, no meritorious constitutional claim that they have a right to come to your dinner.
Someone who's excluded on the basis of viewpoint, so you're inviting friendly reporters or who you perceive to be friendly reporters or commentators.
I think that anybody who looked at just a dinner as opposed to you don't allow people to show up at press briefings altogether, I would be prepared to say that there you are enough off duty, and you are clearly enough off duty because people.
How about a regular meeting, no food is served, but a regular meeting off-site, so not at the White House with certain members of the press and not others?
I think the members of the press put us in a somewhat different position because already you're entitled to limit that in a variety of ways. But if you had a public meeting, for example, in California, a lot of our elected representatives have what they call sidewalk office hours, and they'll sit in the bank parking lot next to the farmer's market, and they'll talk to anybody and they'll hand out stuff. If they decided, simply because they were sitting on the bank's parking lot instead of in their office. I'm not talking to black people. I'm not talking to Muslims. I'm not talking to evangelicals. Yes, they'd be engaged in state action, and yes, they'd be violating the Constitution.
Different tack now. On the reposting question I was asking your friends on the other side about, if your government agency issues a notice and you then repost it,
Well, our case is not about particular posts at all.
Your thoughts on that issue, if you have any, if you don't want to answer.
You know,
it,
I haven't given a lot of thought to it because it's not relevant to our case in particular. But I think
it's going to be very relevant to the opinion. Well,
yes.
how this is
and so what I would
applied.
say is there, if what you're talking about is whether a particular post is state action or not. It may well be that simply reposting something isn't itself state action such that you could challenge your having your comments to that post deleted. But if you were blocked altogether from a website on which they have invited the entire public to share across the public as well as with you what they think, then yes, that would be state action and it would be actionable under the First Amendment.
Ms. Carlin, I just want to be sure that I'm clear about your position. In your test, you're doing your job test. So you agree, it seems like, that the Ninth Circuit test of appearance and function is enough. You wouldn't go with that.
I think that the function part of the Ninth Circuit's test, because they quote this language that the district court's findings made about this being a tool of government, is the appearance and function. When they're talking about function, they're talking about, are these people doing their job? As the function of this is for them to do their job of getting.
How about the appearance part?
Well, the appearance is really helpful in figuring out what is the function.
So it boils down to the function in your mind.
Yes.
Okay.
Yes.
But the function is sort of another word for duty in your sense. Like a duty is a responsibility, is a function. They're all kind of tied up together.
Yeah.
I mean, your duty is to do your job, and that's your function.
And when you do your job, you're doing the function of being a trustee of the Poway School District.
Which brings us back to, this is all a question of how broadly do we define authority or duty?
I think you have to define it more broadly than petitioners.
Oh, no, I understand that, but I'm just saying that
Yes.
then is the nub of the case as you see it. The case
Yes.
totally boils down to how you define it. And I asked the other side a bunch of questions about what work does duty do, is all an authority. I think you would say, if I understand your position correctly, It's just about authority? We're not really looking at duties?
No, we are looking at duty. That's exactly what I'm trying to say is duty. Are you performing the duty of your job as a trustee? If you are, then you are presumptively a state actor. That's what the court's statements in West and Lugar turn to. So
But you would say duty is having conversations with citizens is always part of your duties, or
Well,
almost always part of your duties, which converts every conversation you have.
no, I would say having some mechanism by which you can interact with your constituents is part of your duty. And the board bylaws say this. They say in bylaw 9010A, the responsibility of board members in their role as community leaders is to participate in public discourse. And then they say board members have a responsibility to identify personal viewpoints as such and not as the viewpoint of the board. And here what you have is both of the petitioners using we and our when they talk about what the board is doing, and anybody who looks at that is going to think this is an official website. It looks like an official website. It performs all the functions of an official website. There's no disclaimer anywhere. She has a separate campaign website. She uses her government email.
Now, suppose there's an official website, too, and this, partly, largely, entirely duplicates it. So this goes back to the question that Justice Kavanaugh was asking. How does that matter, or does it matter?
I don't think it would matter if it was the website at issue here, and I really do urge you to take a look at ECF 3511, which has the entire feed from the day she took office until the day of the summary judgment motion. And I defy anyone to look at that and think this wasn't an official website. Indeed, when she wants to give you her personal opinion, she sends you a link to her campaign website.
And I take it that this is the crucial difference between you and the government, right? That they just say Facebook says it's her private property.
Yeah.
And so it's not an official website by definition.
Right.
And you're saying no.
That's correct.
And I'm sorry to be hung up on this duty question, but what if the bylaws or the state law doesn't say it's your duty to communicate with constituents, give announcements, et cetera, but she decides, hey, constituent communication would be a good idea. This is kind of like, well, the governor decides to do this or the president decides to do this. Is that not, even if it's not formally in her job description, and even if she's the first one to do it, so it's not custom, but we would say she has the authority to decide to be the mouthpiece for government. Would you agree that that would be?
Yeah, if I can just say, it's a little complicated in our case because the board has specifically said she doesn't have the authority to speak for the board, and that's why she's supposed to have a disclaimer. But if you're talking about a hypothetical of someone in another jurisdiction where there's nothing that says anything either way and she decides she has the authority, then it would come down to a question of, as a matter of state law, did she have that authority? Because if she had that authority, then yes, she would be a state actor. Now, most government workers, most government employees do not have the authority to speak for the government. And so it wouldn't be part of their duty to run a personal website. And so for most government officials, if you're the janitor or the school bus driver,
Yeah, but that's making it too easy. There are a vast number of government officials around the country at the local, town, city level. So I don't think you can minimize this by saying, oh, it's not going to affect certain categories. It's going to affect a lot of people.
But at the very least, the other side says here, at the very least, if the state wants to tell you not to do this, they can do that. And the answer here is the Poway School District told her not to do this, told her not to have a website that looked as if she was speaking officially. And this website did exactly that.
Just on the custom question to follow up on Justice Barrett, it's usually, I think, as you're describing it, going to be part of the custom of most of these jobs that are elected officials or appointed officials who have some authority to communicate with constituents.
I don't think that that's necessarily true at all.
When wouldn't it be true?
It will be true for elected officials. It will be true for some government officials. But let me give you a hypothetical that I think will illustrate this. So if a public school teacher in Poway had a website that was communicating with the parents of children in her class, that would clearly be state action. And I think that would be true regardless of what she called the website. If she then also wanted to talk about things like whether the board should be elected at large or by districts, which was a big issue here, or she wanted to talk about whether the schools were being mismanaged, which is something that for a while there was a real problem, that would be her speaking in her personal capacity, because that wouldn't be coming from her job and her duties as a school teacher. So just to kind of wrap up, I think—
Do you think, this is a little bit anticipates the next case, if there were also some personal things on this site, how far does that take you? Can you dilute the site and turn it into non-state action by putting up your kids' pictures?
I don't think one picture of your children turns something into not a state website. Here, I really do think if you look at this website, you will find one picture of her children on Christmas, one picture of her children at some school-related event, one picture of her grandfather on Veterans Day, and nothing else that is personal, that is clearly personal, as opposed to coming out of her job. You know, here's the thing to understand, and this goes back to something that Justice Kagan said earlier, which is there are First Amendment issues on both sides of this case. And here, the First Amendment provides a tremendous backstop for members of school boards and the like who want to regulate their sites. There are rules about public forums, there are rules about time, place, and manner and the like, and they have a lot of control over what goes on these websites. But if you decide the threshold state action question against my clients here, refusing to find state action would have devastating consequences for the public, because they would be denied access to the sites on which their officials are talking to them and asking for their reactions. Thank you.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
In some ways, you've complicated things.
I'm sorry.
No, really. Because what we're being asked to find is whether the state was acting when these government officials turned off these sites. So we're being asked to hold the state responsible for ultra-virus activities, because these officials were told specifically, you're telling us now, don't do this, and they did it anyway.
No, ma'am. Just as in, and we talk about this in the red brief, in Monell, the court said you can't hold the government responsible, the municipal government responsible, unless the unconstitutional action was pursuant to a policy. But there was nonetheless a constitutional tort there for which individual government actors could be held responsible.
Okay, thank you.
Justice Kagan? Justice Gorsuch?
No, thank you.
Justice Kavanaugh? No. Great. Justice Jackson? Okay. Thank you, counsel.
Great, thanks.
Rebuttal?
Thank you, Your Honor. So first, on the appearance question, I think my friend said appearance is relevant in assessing whether there's duty or authority, but basically gave up the notion that the Ninth Circuit adopted that you can use appearance as a freestanding trump over duty and authority. I think that concession is basically right, because otherwise the power to block doesn't come from the appearance, and I think she would have to concede my hypothetical where the police officer runs down the street in his uniform is not state action. So then I think the action really does come to how do we define duty and authority. And I think the fundamental problem with Ms. Carlin's submission is that she's defining it too broadly. She's doing exactly what this court said in Kennedy and Lane you should not do. Because you have to recognize that government officials have the right to speak in their personal capacity about their jobs. That's even true about information they only learned because of their jobs. Ms. Carlin emphasized several times that my clients spoke about stuff they learned in the classroom. That's this court's decision in Lane. The square holding of Lane was that it was individual speech, not employee speech, even though it was information learned while in office. And the flip side of that problem is that if you treat this too broadly, the problem that this court recognized in both Kennedy and Garcetti, and the Chief Justice adverted to this, if you treat this as duty and authority just because you're talking about your jobs, that means it's controlled by the state. It amounts to government speech, which means the state itself could tell individuals what to say on their pages. And that's the harm with creating the sort of you have to have a disclaimer rule. If individuals don't put up a disclaimer, all of a sudden, not only do they lose their right to exclude people from their pages, they've now opened themselves up to having the state itself tell them what to say on their page. Not as a regulation, because I agree with the federal government that the state has a lot of power to regulate them as employees. But Ms. Carlin's position means that they could regulate them as such. They could tell them exactly what to do or say on the page. And that would be a serious First Amendment problem. And to say that the First Amendment does all of that because they didn't put up a disclaimer would, I think, turn the First Amendment on its head. Finally, a few points about the facts of my case, because I too would like to win for my clients. So the first point I'll make is that if this is laid out in our reply brief, if you look through the citations to the record, the only duty that my clients had to interact with the public was at their board meetings, which they complied with, and no one was ever blocked from that. Everything else is the same sort of overbroad, it's your duty to talk to people that would cover campaign rallies, talking to your neighbors at church, the stuff that cannot possibly be viewed as governmental unless you swallow individual First Amendment rights. She suggested that the page was somehow their duty. One of my clients closed the page, just shut it down. No one thinks he was acting in breach of his office. He was in dereliction of duty. Your Honor, I see my time is up.
Yes, thank you, counsel. The case is submitted. We'll hear argument next in case 22-611, Lindke versus Freed. Mr. Keatum.
Mr. Chief Justice, and may it please the Court. The dialogue between public officials and their constituents is fundamental to our democracy. Much of that conversation now takes place online, with social media platforms serving as the new town square, where public officials provide important information about what they're doing on the public's behalf and soliciting comments in return. While public officials retain First Amendment rights, use of a private social media account does not immunize an official's conduct from First Amendment or constitutional scrutiny. Under our test for state action, a public official who creates a channel for communicating with constituents about in-office conduct and then blocks a user from that channel must abide by the Constitution. This test, which focuses on how the public official is using and purporting to use that account, is consistent with this court's precedent, under which a public official who purports to act in that capacity is a state actor. It also accords with Section 1983 and the original understanding of what it means to act under color of law. The Sixth Circuit's duty and authority test, by contrast, would provide ready means for public officials to evade the Constitution. Here, for instance, it would mean that the city manager would be free to block from his Facebook page any constituent who is a member of a disfavored race, religion, or political group, free from constitutional constraint. Our test avoids that result while still leaving ample room for public officials to communicate in their personal capacities. I welcome the court's questions.
Would you also win under the doing their jobs test?
Yes, we absolutely would, in part because, as has been pointed out, part of the job of any high-ranking executive official, and the city manager is essentially just under the mayor in terms of being high up in city government. Part of that job is telling people about what you're doing. And what Mr. Freed was doing with his Facebook account, sometimes multiple times a day, was informing the citizens about what he, as city manager, in his role as city manager, was doing for the town, and then communicating directly with constituents about that, sometimes answering their questions about the scope of his orders.
But Ms. Carlin made the point that there are only 3 instances on the website there in the last case that were personal. In this case, just going through the joint appendix, there's quite a bit that is personal. So how would you just factually distinguish that or emphasize the fact that
Sure.
the personal here does not override the official?
So there were certainly a lot more personal posts, although the ratio of job-related posts to personal posts changed dramatically at the start of the pandemic, as you would expect, because a lot of the services and the way that he was doing his job migrated online. I think once you've established a channel for communicating with constituents about your job, I don't think also posting sometimes about your family is going to undo that. Although if what you're complaining about in a specific case is having a comment on a personal post deleted, obviously that would change the equation.
Does it matter if you've established this channel ahead of time and before you became a public official? I mean, you sort of suggested that it had to do with the purpose of the account.
So I think you would look at what you were doing with the page beforehand, or you could, I suppose, but I think it's fairly clear that Mr. Freed wasn't talking about the job of the city manager before he actually became city manager. He wasn't posting about directives that he himself issued until
Right, but I guess
he had
I'm
that
asking,
power.
does it matter whether or not he opens up a new page once he becomes the city manager and begins conversing in the way that we're talking about, or alternatively, he had this page before he became city manager. It had all of his personal information and, you know, pictures of his kids and whatnot, and he just added to the stream of conversation.
So I think that's something that you would look at. Obviously, it would be a factor, but there were a lot of things that changed when he became city manager, not just the content of the posts, but presumably he also didn't list as his website on the page this official city address. He didn't use the community comments at porthuron.org as his email address. There were a number of things that changed by virtue of the fact that he was starting to use this in his capacity as the city manager of the town.
Would it have mattered to you if he had a disclaimer on it?
So I think it probably wouldn't get you back over the line into personal use, in part because of the way that he was using it to make certain announcements and issue directives, information that you wouldn't necessarily be able to get anywhere else. And certainly there was no other place that you could go to interact with the city manager. Now, it would have, I think, been something that they could argue that he was using this in a personal capacity, but I think the disclaimer would have been substantially overridden by the way he was actually using the page.
Just to be clear, if the page had not been created until he became city manager, would the case come out the same way? Should it come out the same way in your view?
It would, although perhaps it would be even clearer than it already is.
It would be, okay. What if 95% of the posts are personal and 5% of the posts involve a discussion of his work?
So it would obviously be a more difficult argument for us to make, but I would still be here certainly as my client's attorney telling you, look, if there's only one place to go to interact with the city manager about directives that he himself had issued, the fact that he posts a lot about cats or whatever personal thing he wants to post about, that doesn't change the fact that if you get blocked off from that page, you're suddenly losing access to a lot of information.
So if it's entirely personal, but once he slips and he talks about his work, that changes it?
I think it does because it's not really being established as a channel of communication. It's a little bit like running into someone at the grocery store where maybe they let slip some information about the way the government is working. That doesn't mean that they are going to the grocery store in order to interact with constituents. But you could obviously change the hypothetical where they say, I'm going to hold office hours every Friday in the grocery store for an hour to talk with citizens about pending legislation and what I'm intending to do.
So I'm not sure about what the line that you're drawing. You said if it's 5% official, 5% work-related, then it's state action. But if it's like 1%, 1/2 of 1%, it's not? Is that what you're saying?
So it's not a quantitative test, it's qualitative, but the quality that you're going for is whether you've established it as a channel of communication. And I thought I understood your hypothetical as essentially just one thing you said one time. There's no understanding or expectation that you're using this as an ongoing channel of communicating with constituents.
I'm confused. Is it the channel that we're supposed to be focusing on? This gets back to the Chief Justice's first question in the last argument. Or is it the message at issue itself? Because I had thought I heard you say, if the message were about a private family matter and you were blocked from that, you wouldn't have any recourse. So which is it? Is it the channel or is it the message?
So I think in part it depends on what function you're complaining about. If your complaint is you're being blocked from access to the page, then it's the channel that matters. It's the entire page and your access to information. If, on the other hand, you're complaining because your comment was deleted from a post, it obviously matters what the post was about. If it was a post about cats, then you don't have any constitutional complaint.
What if the individual harasses the public official on all of his personal, cat pictures and children pictures, and he finally gets fed up and he just blocks them?
Yeah. So I think
from the channel.
Sure.
So then that's state action.
So I think it could be in the exact same way that it could be if, for instance, you were on an official page of the town and you were being harassing. At some point,
No, all the harassing in my hypothetical has to do with cats.
No, I understand.
The commenter hates cats.
Sure.
And maybe he hates your children too. I don't know. But if I block a person for that, at some point, even though it's all my personal stuff, that's state action.
So I think, again, let's say, in official town pages, all the time they say, here's someone enjoying themselves in the park. And let's say you posted something.
I understand you want to change the hypothetical. I get it. I get it. But just answer mine if you
Sure.
want.
So the answer is there still would be state action, but it would probably easily pass the First Amendment, and especially with a qualified immunity overlay, it would be a very easy case. There would be no
but there's
problem.
litigation. I don't want to interrupt.
No, please interrupt.
I mean, once it's state action, then there's an issue. And I guess one of the concerns I have about your position and just the line drawing is to define doing your job as talking about your job is really quite all-encompassing, really, because a lot of elected officials I've been around love going to the grocery store and talking to people after church, and that's where they learn things to help them do their job better. And they're thinking in their mind, yeah, I'm going to church, I'm going to the grocery, but I'm also going to pick up things.
Yes.
Or going to the game, or going to the high school football game on Friday night, and I'm going to see a lot of people, and that's going to help me get my finger on the pulse of the community about whatever issue it might be.
And I understand that, but I think that's what the distinction between talking about your job, which you might do at the grocery store, and establishing a communication with constituents about your in-office conduct, which is something that happens on an ongoing basis.
So the two key words I think you used there were establishing and channel. And I don't know what it takes to, quote, in the brick and mortar world to establish a channel, but if you have a regular pattern of seeing a group of people. I want to meet at my house with old friends regularly to talk about what they think's going on.
So I think
in the community for purposes of helping me figure out what legislation to propose as a state rep, say.
I think there, if you were just issuing an invitation to your friends, that's very different than issuing a general invitation to everyone in the town, all your constituents, who you basically say, I will interact with anyone who comes, but according to my friends from the other side, you could essentially say, but only the white citizens of the town are invited.
Right. But it goes back to who you want to include and who you want to exclude, I guess. And I think elected officials and appointed officials rely on groups of people who are supporters, friends, people they've known, people who are fair-minded, not people who are just going to come and scream at them, to get advice, thoughts, including negative and critical thoughts. But they want to exclude, the person who's the jerk who's going to interrupt the whole thing.
So I think it's easy sort of on the extremes where either you're just inviting an old friend or you're inviting everyone in the town because they're constituents, which is essentially what Freed was doing. In the middle, I grant you there will be difficult cases where it sort of seems like you are inviting everyone only that you like, or there may be other ways to divide the hypothetical. But I think in a case like Facebook, where essentially anyone with a profile could look at Mr. Freed's page, I think it's relatively clear the invitation was to everyone in the town.
Can I direct your attention to what I perceive to be a difference between your position and the one that Ms. Carlin just articulated? And maybe there is no daylight, but I would be helpful to understand if there is. You've said repeatedly here that this is about whether or not the page has been established as a channel of communication, which sounds to me like a species of the appearance. We are looking at this page and we're seeing how it operates. I understood Ms. Carlin to be saying, well, really her test is, are you doing your job? What are the duties and functions of your position? And have you created this page, and does it operate to facilitate your job duties? Are you at all, so is there a difference between those two? And are you also relying at all on the sort of duties or functions, whether or not the person had to create the page or something like this?
So I think if they had to create the page, that obviously is game over. But we agree with the respondents in the prior case that there has to be a broader conception of what duty encompasses to mean everything that is sort of customarily expected of you in your job. For a high-ranking executive official, usually that's going to be talking about your job, at least in certain established ways.
But I didn't hear your test to be about duty at all, really.
Yeah. So
is it?
So I think the answer is, it is certainly sufficient if you have a concept of doing your job through your page. We think that we have that here. We also have a slightly broader principle that if you hold yourself out as doing your job through your page, that is also sufficient, which I don't know that my friends on the other side, on a respondent in the first case disagrees with, but they aren't relying as much on that principle.
And your hold yourself out in this situation is because we can look at the page and we see that it has been established as a channel for communication with the constituents.
Yeah, so that's partly the way that you design your page and partly what you do with it. Here we have both his profile and the way that he was posting and what he was posting about.
I would have thought that what it looks like is the worst test for you, because what this looks like is there are a lot of baby pictures and dog pictures and obviously personal stuff, and intermixed with that there is, as you say, communication with constituents about important matters. But it's hard to look at this page as a whole, unlike the one in the last case, and not think that surely this could not be the official communication channel.
So,
or what,
Yeah, so I think
it's not like any town I've ever seen.
Right. Well, I think small town government works in different ways. Obviously, there was some personal stuff as well. But the way that he was talking about the posts, referring to things in the plural, the way that he was posting things that were directives that he himself had issued only minutes earlier, and then answering constituent questions about that. Now, admittedly, he was also talking about personal things, but you can't essentially immunize yourself from constitutional scrutiny if you've established this government channel of communication just by also posting about your dog.
Well, what do you say to the Chief Justice's concern at the outset of this conversation about the free speech rights of civil servants? And we're numbering the millions now across this country. And if it is within the scope of your duty, and if you're going to define that very, very broadly, you give the government a lot of power over limiting what what many millions of Americans can say. And surely that must be some concern to you.
It is a concern that has to be balanced against the right of people in the town. I think there's some irony that the petitioners in the first case in the United States say the way to solve the First Amendment problem is for the government just to tell people how to use their pages.
Well, and there's some irony on the other side to say the way to solve the First Amendment problem is to turn it all into government speech, so the government controls what millions of civil servants in towns, large, small, and the federal government alike, what they can and cannot say in the public forum.
So admittedly, there's going to be some issue of government control, but I don't think that's escapable. For instance, if the mayor of Port Huron had wanted to, she obviously could have told Mr. Freed, either stop posting your directives to your personal page, or when you post them, also post this additional information. Or when you answer a question about this directive, answer it in this way. So that sort of control is already going to be there, regardless of whether he's considered a state actor.
It would be on a clearly public page.
As
the
his,
question,
yes.
Clearly, the question is whether it might also have to be on a page maintained, somebody thought personally that they came up with before they became a government official, that's mostly populated by dog pictures, and whether the government can also mandate what the person can say there. And if that's the case, what's left of that person's free speech rights?
So
I mean, we used to care about public employee private speech rights, Garcetti, Pickering, you know.
Yeah. And I think, as your question alludes to, there is a doctrine under the First Amendment that reconciles the First Amendment rights of a public official against the government's interest in the speech. One of the key points that we're making is the exact same factors that you look to decide whether the government has an interest in the speech and therefore has some control over it, even when it's ostensibly private speech. Those are things like, are you purporting to do your job on the page? Are you holding yourself out as a public official? And if so, can the government tell you, if you're going to use your title on your page, as many people do, just make clear you are saying this in your private capacity. And if the government can say that to you, consistent with the First Amendment, then you sort of understand that there's not going to be a different First Amendment equation just because we're calling it state action as well.
Well, I mean, on these pages, people have both a job in the government and they have all sorts of other things, whether it's cats or children or whatever it is. And the problem, it seems to me, is we kind of have to disaggregate that, right, and say, well, you know, you have to have a governmental page and you have to have a private page, and you can't mention the government on your private page or else it's going to become a government page. And as I understand it, you basically say if you've got 5% government, then we, the government, can basically say the whole thing, even if the rest of it is all about your children and the dogs, that's ours. And if we don't like little dogs, we can say, you can't put pictures of little dogs on there. And it seems to me that effort to kind of disentangle the two things doesn't really reflect the reality of how social media works.
So, Your Honor, I have to push back in two respects. First—
About the dogs, or?
A little bit about the dogs. So one principle is it's not the 5% versus 95% that you've gotten over some threshold. It's the way you're using your page as an ongoing place where people in the town go to get information about what you as a city manager are doing, how you're doing your job, the directives that you issue. If you set it up that way, that's the quality that you're looking for.
Well,
it's not
just
quantity.
I don't mean, well, I do mean to interrupt, but well, what if you're doing, you know that from your you know, the official weather, whatever, a very bad storm is coming. You also know that not everybody checks the city site, you know, 12 times a day. But you know a lot of people look at your private site. And if you put on there's a very bad storm coming, or I looked at the city weather, whatever, you need to know there's a bad storm coming. Does that compromise the private nature of your page?
No, again, you haven't set up an ongoing channel for communication where people know that's the place to go in the future for important information.
Well, why do you know that
second—
this is an ongoing channel of communication? What do you look to decide that? And be specific about this site.
Sure.
What on this site indicates that this was what you consider an ongoing channel of communication, as opposed to just a place where you talk about your dogs, you talk about your children, and you talk about your work?
Sure. So I think as soon as the pandemic started, there were multiple posts a day about what he and other people in the government were doing. Usually he was going to post a daily COVID update from the basically health equivalent of the CDC. He was posting directives, so I could direct you, for instance, to the directive on page 22 of the Joint Appendix. There's another directive on page 20 of the Joint Appendix. And then the specific post that was the subject of the dispute with my client, that was flanked by a post about a community operations outreach center on one side and a place to donate for people who were struggling on the other side. So there were just multiple posts a day about this. And he was also interacting with constituents. So one of the key features I think that you would lose out on is if you go back to page 22 of the Joint Appendix, he issues this order about cutting off water. And he says, basically, effective immediately, we're not going to cut off water for 30 days because of the pandemic. And then there's a question from a constituent below who says, well, what about people whose water is already cut off? Are those going to be turned back on? And he answers yes. So there's essentially a real-time gloss on his own directive. And it's possible that the directive appeared somewhere else. There's nothing in the record about that, but it presumably came a little bit later. And if you wanted to know what is the city manager, who's essentially the chief executive officer for the town, what is he doing? That's the place to go. There was essentially no other game in town for figuring it out if you were a citizen of Port Huron.
Well, that makes it pretty difficult for a public official or city manager to have any kind of private site, because he could have a private Facebook page populated with pictures of his dog, pictures of his kids, and one of his friends asks something about the water shut off, and he says, you know, yeah, the water's going to be shut off, you know, et cetera, or a storm's coming, whatever. Has he then transformed what he thought was his private Facebook page into something that is state action, and so he arguably has to give everybody in the town access to, when he might not want to give them, you know, access to pictures of his kids? Or does he have to tell his friend, sorry, I can't answer that question here, head over to my public Facebook page and I'll answer it there?
So that sounds a lot to me like the sort of Facebook equivalent of just running into someone in the grocery store. I don't think that that creates any sort of channel that way. Although the best practice is obviously to refer someone, you know, for more information, go to the official page.
Creates nightmares of litigation though, right?
So it could create nightmares of litigation. I think literally whatever you say here, unless you essentially say nothing that happens over Facebook is going to ever be state action, which I don't even now take any of the parties to be arguing. Unless you say that, you're always going to have some amount of litigation. The good news is our test has been the majority test in the circuits, and I think the reason that you don't see a flood of litigation, there are basically only 5 Court of Appeals decisions, including the 2 cases before you, is number 1, you've got the qualified immunity overlay. Number 2, most of these First Amendment claims are not going to have much to them. They can be dismissed on reasonable time, place, and manner restrictions.
Why isn't all of Facebook the equivalent of running into someone at the grocery store, unless on that personal page you're announcing some governmental rule or some official notice of some kind, and we can debate what official notice is?
So I think Facebook, as this court has said in other cases, and all of these social media platforms are incredibly powerful in a way that running into someone in the grocery store is not. This is not just an incidental place where you happen to receive speech from someone. You know, in the olden days, if you were a public official and you wanted to communicate with the public outside of formal channels, you probably would have had to walk out of your office, maybe find a payphone if you remember what those still were. And it would have been very difficult without the use of your staff to communicate to the public in any sort of broad way. These social media platforms make that basically instantaneous. You can cast as wide a net as you want, talk to everyone in the town. You can talk specifically to individual people. They are just incredibly powerful in a way that I don't think that just the happenstance of running into someone in the grocery store is. I think the better analogy, if I may tweak yours, is essentially just saying, you know, I'm going to post my private phone number. Everyone in the town can give me a call if you have problems with your leaf collection. Oh, but by the way, only white citizens are allowed to use this phone. I think that would also be constitutionally problematic, even though you were using your own private phone number.
Thank you. Justice Thomas? Justice Alito? Justice Sotomayor? Justice Kavanaugh? Justice Barrett?
No.
Justice
Just
Jackson?
one final question. I guess I don't understand why this test that you have articulated doesn't require the sort of post-by-post analysis. Because I appreciate that you say that this is an ongoing channel of communication because we have some posts that give the kind of information and ask for public feedback, but you also concede that we have other posts, a substantial number of other posts that are private. So first, I guess, what is your answer to, could the public official who uses this to communicate with the public sometimes, could they block a person who made comments about the dogs or not?
So certainly they could.
Is that state action?
Right.
Excuse me. Is it state action to block a comment about the dogs?
So I think the answer is, if you're talking just about removing a comment from a specific post, it is only state action if the post itself has something to do with the job. And I think this goes back to the Chief Justice's questions about whether all of a sudden it means that you basically have to let the government control all the posting that you do about your cats or dogs.
Right.
The answer is no, because the posting about the cats or dogs is not state action. But if you're talking about blocking someone's access to the entire page for all time on a going forward basis, then obviously it matters not just the specific post that led you to take that action, but all of the other information that they're losing out on.
So you're saying there is a situation, was that the case in your situation where the block resulted in no access to this page at all?
Yes, so two things happened. He had comments removed, but also he was blocked so that he could not access the page when he was signed in. And there were 4 other people who also either had comments deleted or were blocked, all of whom because they essentially criticized the way that Mr. Freed was performing his job as city manager.
Thank you.
Thank you, counsel. Ferris?
Mr. Chief Justice, and may it please the court. This country's 21 million government employees should have the right to talk publicly about their jobs on personal social media accounts like their private sector counterparts. As this court addresses the question presented, this court should adopt the Sixth Circuit's duty and authority or state official test because it complies with this court's precedent and requires that a government employee is either exercising power possessed by virtue of state law or made possible only because he is clothed with the authority of state law. Petitioner wrongly advocates for an inherently subjective test that divorces the state action inquiry from state law. Petitioner's test will result in uncertainty and self-censorship for this country's government employees, despite this court repeatedly finding that government employees do not lose their rights merely by virtue of public employment. James Freed's Facebook account is the perfect example of the danger of Petitioner's test. Mr. Freed opened a personal Facebook account in 2008 as a college student at Indiana Wesleyan University. For 12 years, he built up the account to interact with friends, family members, and colleagues to talk about his passions and interests, including his wife, daughter, his dog,